Hi, I'm George Nordhaus of Monday Morning Markets, and welcome to another product knowledge video. This one is on a coverage that everybody or every business person needs to know about: directors and officers liability insurance. And it's very, very difficult to run a business with directors and officers and not understand liability insurance. But that's taken care of pretty easily here because of Bob Sargent. He is the president and CEO of Tenant Risk Services, and they service people, agencies, etc., all over the country, probably all over the world. At any rate, Bob is the acknowledged expert. He was even president of the National Association of the Surplus Lines folks, which is, again, we won't get into in depth here. But Bob's going to tell us about directors and officers liability insurance. So, Bob, let me ask that question. What is D&O?
Thank you, George. D&O stands for Directors and Officers Liability Insurance, and it's also sometimes called management liability, so don't be confused by the name. It can get somewhat complicated. So make sure you have an insurance representative to help, and of course this video will provide some of the basics.
Good. Well, all right, let's ask that. What does it cover?
Well, in legalese, D&O insurance is designed to protect directors and officers against legal judgments, lawsuits, and the related defense expenses resulting from allegations of wrongful acts committed in their capacity as directors and officers. So what this means is that D&O provides a financial protection for directors and officers if they get sued.
I got it. Well, who is? I got it. I got to ask about who is covered by it.
Typically, D&O policies cover both directors and officers and the organization itself. In certain cases, other entities or individuals might be included. So, for example, volunteers of a nonprofit organization would be included in the definition of an insured for a nonprofit D&O policy.
I got it.
And likewise, subsidiaries of private companies are also typically covered as insureds under a D&O policy.
All right, and let me ask you this. What's the most important points to keep in mind while we're thinking about D&O?
Well, a couple of things that we've seen come up, which we always put at the top of the list. So one common misconception is that D&O is not the same as errors and omissions or E&O insurance. In fact, most D&O policies specifically exclude E&O exposures of a professional organization because the underwriters and the insurers expect the organizations to purchase E&O separately.
I see.
So that's one thing just to make sure that is kept in mind. Secondly, D&O policies typically include coverage for employment practices liability insurance, or called EPL. And EPL exposures are quite different from D&O exposures, and of course are significant. So, and we can get into that more later if you want. And third, and maybe most importantly, is that D&O provides personal financial protection to the individual directors and officers. So the way we look at this is a critical component of D&O insurance is the financial protection provided to directors and officers as individuals. And it is important to remember that unlike many other situations, directors and officers can be sued personally, and the D&O is really designed to provide protection of the personal assets in that situation.
I see. Well, who needs it? I guess that's the next question. Who needs D&O?
Well,
everybody.
George. Everybody, yeah. All organizations, I would say the exposure and the coverage is a little different, and D&O insurance is divided into sort of three segments. One is private companies, then not-for-profit or nonprofit organizations, and publicly traded companies. And in the business, these are typically referred to as private company D&O, nonprofit D&O, and public D&O.
I see.
And of course, publicly traded companies are those whose stocks or other securities are registered with the SEC and traded publicly on one of the stock exchanges. And for those companies, the driving exposure really is related to the securities, the public securities that are issued. Private companies are a little bit different, but the exposures are generally lower, and the premiums, of course, are significantly lower. And the key exposures tend to be from shareholders, customers, vendors, and even competitors or regulators. And lastly, nonprofit organizations, the driving exposures are typically employment-related, but also the personal exposure of the directors and officers as well.
Got it.
Sort of another angle on the nonprofits is that many states have what's called a safe harbor provision that protects the directors of nonprofits only from judgments if they meet certain hurdles of conduct. The problem with these safe harbor provisions is that they don't protect from a lawsuit being filed. So even with the existence of these safe harbor provisions, D&O insurance is critical in making sure that the individual directors and officers of the nonprofit have the financial resources to defend a suit.
Well, it sounds like it does. One policy doesn't fit everything. I guess that's for sure. Can anybody buy it?
It's definitely.
Yeah, I'm sorry to interrupt you.
Yeah, anybody can buy it, and the organizations are not all the same, and so the exposures aren't the same, and the coverage varies. You know, some have more exposure than others, and there's certainly some types of organizations that are more complex or harder to place, or from the underwriter's perspective, riskier. And it doesn't mean that those organizations are bad or that there's no insurance available. It just means that the underwriting process may be a little longer. So, you know, you do get these harder to place situations. Examples might be accounts that have multiple claims. There could be bankruptcy situations or other companies involved in higher risk activities. So, and yeah. you probably want to know how the coverage varies, right, well, George?
Yeah, I certainly do. Yeah.
You know, the coverage is sort of critical, and the forms can vary certainly by each segment. Nonprofit organizations are quite different, and the exposures are different from, say, private companies or public company, and therefore the D&O forms would vary. There's certainly some specialty situations as well that dictate different coverage. So, you know, one example is certain investment management companies typically buy E&O with their D&O form, and so they have these combined forms. And then you get sort of a different situation with a bankrupt company in workout that might need a specially tailored form for its particular situation. Mm-hmm. So, and then you get things like special partnerships, educational institutions, trustees, and even coverage for individual directors, and all those kinds of situations would have specific forms or form variations for them. Mm-hmm. And, you know, the insurance representative, the insurance agent can provide direction with a support from a specialty broker like Tenant Risk, a wholesaler, in making sure that the right coverage is provided and in a competitive fashion.
I always thought that, maybe I'm wrong, I obviously am wrong to a degree, I always thought that D&O could be, it was a package, as you'd buy it with everybody else. I mean, it would be automatic, that it would be, when you buy another policy, it would be there, but no?
Well, no, it's not. It's typically provided on a standalone basis, but it is packaged in a different way with other coverages sometimes. It's fairly common for D&O to include employment practices, liability, or EPL, and sometimes fiduciary liability and a couple of other coverages as well. Mm-hmm. Employment practices liability insurance is pretty important, commonly referred to as EPL. And a critical component, EPL provides protection for claims against the insured entity and the individual directors and officers for claims related to employment exposures. And the primary employment exposures relate to wrongful termination, sexual harassment, and discrimination, but there are some employment exposures that go way beyond these three segments and can be complex. So underwriters will typically cover both D&O and EPL together on a policy, either within one limit or offer separate limits for each of these coverages. And in most cases, particularly for nonprofit and private company D&O situations, the employment practices is part of that D&O package. And as I said, sometimes fiduciary liability as well, and some other coverages.
What is not covered? I guess is my next question.
Well, that's a great question. You know, like most insurance policies, D&O does not cover, you know, fraudulent, criminal, intentional acts, situations where the directors may have been operating for personal profit or were getting remuneration that they were not entitled to. So you have that sort of intentional fraudulent act exclusion. But for innocent directors, there's typically a provision in D&O policies that innocent directors and officers can remain fully covered if they are named but did not participate in any sort of you know, fraudulent or intentional activity. You know, you do get situations where D&O policies exclude other activities which are not intended to be included, and we talked about one example of that would be E&O or professional liability. D&O is not intended to cover professional services, and therefore there's an exclusion for that as well. And you know, I guess I'd add one more point there, where private company D&O policies typically exclude coverage for public offerings of securities. If a private company is going public, there won't be coverage for that offering. It's not because that coverage is not available. It's because the insurer or the underwriter wants to know when that's going to happen and have an opportunity to re-underwrite the risk. And in those cases, a public company D&O policy would probably be issued.
I bet the claims are interesting to see. I asked you for some examples. How about telling us about some of those?
Sure. You know, it's interesting. D&O claims are, as you might expect, sort of run the gamut. There was a study by Chubb recently that noted that the average cost of a D&O claim was around $700,000, so they definitely can be significant.
Oh, yeah.
Claims can come from many different sources. You know, you've got some of the examples we talked about here. Certainly, in a nonprofit, you can have a situation where a donor can make a donation, and the example you have, naming a building after his favorite pet, you know, and if the nonprofit does not follow through on that, there can be litigation, and this has happened more than once, definitely. You know, certainly a public company who has an offer and the board decides that they don't want to accept the offer, you know, many times the stockholders will sue, and they'll claim that the directors were happy with the situation and didn't want to lose their job as directors, and the stockholders will lose it out. So you do get that kind of a suit as well. The third point you have here is actually an EPL claim, and this kind of situation is not uncommon under a D&O policy, a wrongful termination in this case. And lastly, you know, you get these claims now where something occurs and the claimants, the plaintiffs, bring a claim saying the board was not providing adequate oversight and could have had the opportunity to prevent the situation from occurring. So that, in many cases, is a D&O claim as well.
Well, they're all over the lot. I bet it's kind of an exciting thing, isn't it? Because they're just not. I mean, it's not something gets burned down and you pay for it. It's there's a lot of legality involved. I imagine the lawsuit percentage on these claims is pretty high, isn't it?
It is. I mean, it's not. You know, the frequency is not all that high, but when the claims are made, they can be really very difficult. You know, the lawyers get involved on both sides, and it requires a lot of time and attention. It can be a huge distraction because typically, you know, the directors and certainly the officers have to spend a lot of time on this in addition to the legal fees that go with it. So even when you win, it's an expensive and time-consuming endeavor.
I can imagine. I imagine everybody in the business knows about it too, and I imagine there's a lot of talk around the tables. At any rate, how about some recommendations on your part?
Well, I think the you know, the key recommendation in anyone going to purchase D&O coverage is to make sure you partner with a broker who has access to a range of markets, typically through you know, a wholesale specialty broker like our own organization.
Sure.
And make sure there's access, make sure there's expertise. Not all the policies are the same, so it's important to make sure that the policy is appropriate. It's not always just about price. The combination of appropriate terms and price is critically important. And there are, you know, risk management offerings that go with many of these D&O and EPL policies that can be beneficial. There's a lot of expertise in the business about this coverage and the exposures, and you know, I would encourage insureds to reach out and make sure that their boards understand the exposures that they have in serving and have a comfort level in the D&O insurance that the organization has purchased to protect themselves.
Thank you, Bob. I think I've got a pretty good handle on things now. I would like to thank you and Tenant for helping us with this, and I would like to suggest that you go back to the agency who sponsored this. Click on it, connect now, and agents pretty generally understand this as a basic coverage, and they can, of course, go much further than Bob did in these few minutes, but the concept is to get that expertise, use it, make it work. So, Bob, I want to thank you again for sharing all this with us, and we know where to go if we want the expert, and that's Bob Sargent, right? Well, you would say so. I say so anyway. Thanks again.
Yes, thank you very much, George. Appreciate it.